So now, without further ado, I would like to introduce to you our next speaker, who is a top expert, who is instrumental in drafting the proposition. And she is the president of California Deputy District Attorneys Association, Ms. Michele Hanisee.
Mr. Lee, thank you so much for inviting me to speak at this event, and thank you for your support of Proposition 20. You know, just last week I was listening to Senate hearings in Sacramento, and one of our legislators said, we write laws that aren't always perfect, but we have the opportunity to correct them with new laws or new amendments, and that is the process that we are looking at here. Prop 20 will correct some of the unintended consequences of Assembly Bill 109, Proposition 47, and Proposition 57. AB 109 created a new kind of post-release supervision under the probation department for parolees, but the new system has been at times problematic because the judges who impose sentences were not being notified when a person violated the terms of their release. Prop 57, as you know, was represented to the voters is only affecting non-violent offenders. The governor himself said it was only supposed to apply for early release for non-violent offenders, and he took the position that it would never permit the early release of sex offenders. Well, we know now that that was incorrect based on the way it was written, and courts have found that sex offenders are eligible for early release as are third strikers. So to make the law what the governor promised to the voters, we need modifications, the modifications contained within Prop 20. Prop 20 would correct that and would define as violent all the crimes that actually are violent. Prop 47 was called the Safe Neighborhoods and Schools Act. But what happened is it allowed criminals to walk into a store or open a car door and steal up to $950 of property as many times as they want without ever facing any increased penalty. So no matter how many times they steal, as long as the amount is under $950, they will always be punished the same as a first-time offender. So not surprisingly, statewide property crimes went up immediately following the enactment of Proposition 47. Proposition 47 also decriminalized all drug use and effectively eliminated mandatory drug treatment for addicts, which has had a terrible impact. And lastly, without ever intending to, Proposition 47 eliminated DNA collection for a lot of these crimes by reducing them to misdemeanors, and this resulted in fewer crimes being solved through the technology of DNA. Prop 20 would fix these issues without increasing the number of people sent to state prison. And Mr. Lee spoke about some of the main components of it. It expands the list of violent crimes that are ineligible for early release, and he told you what some of those were. I want to emphasize it does not add strikes to the penal code, and it requires reasonable notice to victims when their attacker is scheduled to be released early. It also reinstates DNA collection for certain crimes that were reduced to misdemeanors under Prop 47. And this is important because multiple studies have shown that DNA collected from theft and drug offenses help solve violent crimes like murder, robberies, and rapes. In fact, the Department of Justice study shows that for murder cases solved with DNA, 30% of that time, that DNA comes from someone convicted of a drug offense, and 29% of the time, the DNA was collected from someone who was convicted of a property crime. But since passage of Prop 47, cold case DNA hits have dropped drastically. It would also make serial theft, when a person's convicted of theft for a third time for a dollar value of over $250, punishable as a low-level felony. It's called a wobbler. It's actually punishable as a misdemeanor or felony. When Prop 47 changed the dollar threshold to $950 for felonies, there was an explosion of serial theft and an inability of law enforcement to prosecute these crimes effectively. Theft increases since Prop 47 have been in the tens of billions of dollars, and it's our merchants who suffered, and they're of course going to pass those expenses along to the consumer. Prop 20 would de-incentivize serial theft offenders and organized theft rings by increasing punishment for those groups specifically for repeat offenses. And it also allows the aggregation of theft offenses by organized theft rings. when Governor Brown was promoting Prop 47, he believed that prosecutors had the ability to aggregate theft losses for purposes of felony charging, but the courts have said that is absolutely wrong and they do not. Prop 20 would fix that, and it would allow the aggregation of theft amounts by serial theft offenders and by organized theft rings. And again, I want to emphasize, none of these wobbler offenses under Prop 20, none of them are punishable by state prison. They're all low-level felonies. AB 109 created a new kind of parole, as I mentioned, called post-release community supervision. And what happened is parole was in charge of supervising people and could give them something called flash incarceration, but these people weren't being sent back in front of judges when they violated. And we have instances like the murder of Whittier police officer Boyer by inmate Michael Mejia, who was on post-release community supervision, and he'd violated the terms of his release multiple times without ever going back in front of a judge and having a judge consider violating him and sending him back to prison. So Prop 20 would fix that by requiring probation to notify the court of a third violation. It doesn't require more punishment. It requires that the individual be brought in front of the judge so that the judge can make that decision. In summary, Proposition 20 is very conservative. It doesn't propose to do any of the stated intents of AB 109, Prop 47, or Prop 57. To the contrary, what it does is it brings those laws in line with what was originally promised to the voters. And that's why we're putting forth this measure, so the voters get what they were promised. Thank you very much.
Thank you, Michele.